So in thinking about this, it occurred to me that if you look at the Melendez-Diaz case, which I hope you're all familiar with, Melendez-Diaz, of course, essentially said that the Ohio versus Roberts rule no longer applies. The first question is whether or not the document that the opposing party wants to use is testamentary in nature. If it's testamentary in nature, the rules of evidence, more specifically the hearsay rules, don't apply. That's the wrong standard. Why? Because it's a constitutional determination at that point. Because if it's testamentary, you have a right to cross-examine. So what they're saying is it's not a question of what the rules say, it's a question of what does the Constitution say, because it's a constitutional standard. So in thinking about that and applying it to this, it occurred to me that Daubert is really like the rules of evidence, isn't it? It's a question of whether or not, and by the way, we all know, I think, that Daubert deals with a civil issue. It's a civil case. It's not a criminal case. Daubert has been applied in some instances, at least around the fringes, to criminal matters, but that whole progeny of cases, they're all civil. And the rules are different in civil cases because there's no Constitution. When you're dealing with a civil claim, the Constitution is not an issue. It's the issue in a criminal case. So the first question is, do we have a constitutional issue? And if we do, then Daubert doesn't apply. And it really deals with whether or not, by excluding your witness, the court is essentially precluding you from raising a defense. Because obviously, we know you have a right to call witnesses in a criminal case, to offer the testimony of witnesses and to compel their attendance. A defendant in a criminal case has a right to present the defendant's version of the facts as well as the prosecution's to the jury so that it may decide where the truth is. If the only way that you can do that is by bringing an expert into the courtroom, Daubert is not the standard. There's a different standard that applies. Just as the accused has the right to confront the prosecution witnesses for the purposes of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is fundamental. It's a fundamental right. It's a fundamental due process right. So what's the standard? Well, in doing some research in Michigan, I came across these cases, and really, in order for the court to find that your expert is not allowed to testify, the court has to find that it's an egregious case, that the witness's testimony is really pretty far out there. And there's a whole line of cases that deal with what are, for all practical purposes, made-up defenses.